Yeah, so in that regard, we began by discussing how hate speech is classified in the US, and we discussed about the clear and present danger test. So in the instant video, in the instant scenario, what we noted is the journalist, he was basically presenting a particular narrative, a particular opinion rather, and he wasn't um, calling for any particular action, or he wasn't inciting any violence or anything of that degree, or hurting the listeners to such an extent, or dehumanizing them, or insulting them, or characterizing them to a particular class. So we do not think that it qualifies the clear and present danger test. It does not incite any violence. And considering the degree of free speech is much higher in the US as compared to India, the First Amendment right is much more liberal and promotes free speech to a much greater degree and allows for opinions and narratives. We believe that the first video does not amount to hate speech if it was in the US context.
Thank you, Chino. Would like to, then maybe we can discussions.
Sorry, I lost you there. Should I go? Should I go next? Yeah. So I think we agree with what Gino told. So can you hear me? Sorry.
We can hear you, Naveen. Yeah.
Yeah. So we agree with what Gino told. We fundamentally believe that the US free speech provision is much more liberal in the sense. And I think one more thing which I picked up, which didn't cross our minds during the discussion, is that this particular video of the person establishing all those whatever opinions on that video, like it may or may not be true. Like that is not up for question. Even if it is not true, it may be classified as fake speech, but not really as fake news, sorry, as fake news, not exactly hate speech, because he's not inciting violence or doing anything that may cause harm to any other community, even though like whatever he may be saying might mean like that. But fundamentally speaking, from a constitutional perspective, I think the US free speech provision is much, much more liberal. So that allows for a lot of people to offend each other as well. So I don't think it is anywhere even near it being like restricted or banned in the US. So I think that is absolutely permissible in the US. And talking about the second video, I think if that video, like say that kind of marching took place in India, it would definitely be restricted under the reasonable restrictions to free speech, because it's very clear from what they're saying that like the slogan saying that our blood, our soil, which clearly says that they do not want anyone else who do not belong to the white race to be the Caucasian race. And they did this through a Jewish neighborhood, which is very clear that they wanted. Uh, it was anti-Semitic in principle. So therefore, for that reason, it would be uh, curbed under the reasonable restrictions under Article 19. And secondly, even the words which are used over there, it is inciting violence. So there's a lot of reference to blood and taking over the land. So it's very clear that those are some kind of hidden meanings to start an uprising to get rid of Jews from that neighborhood. So it is inciting violence as well. So even that would be covered under the reasonable restrictions under the Indian Constitution. And this would definitely, at the end of the day, result in damage to public order and morality. So for that reason as well, it would definitely be restricted under the Indian Constitution.
Thank you, Naveen. So what I understand from both sides is that the Indian video might not amount to free speech if it were in the US, while the US video would amount to free speech if it were looked at under Indian provisions.
And you mean hate speech, sorry.
Oh, sorry, hate speech. Yeah. And this is because of course, reasonable restrictions in India. I think it's also interesting to note here that I think Naveen mentioned earlier on today about how a similar march had actually taken place in the US and the courts hadn't considered it as hate speech. So I think it would be interesting to discuss how the two laws, in fact, are so different from each other, especially in the context of communal violences or just instances such as the ones that we showed in the video.
Just just a quick point is, in fact, the Indian video that we all saw. The court actually stopped the airing of this show. The Supreme Court intervened after 4 parts of the show had been aired. They had actually intervened and stopped it on grounds of promoting hatred and enmity. So it's just to sort of see how that video played out in the Indian context eventually. And if you do look at the sort of video that we saw in the American context, interestingly, if we go back to the RAV versus City of St. Paul case, maybe they would not strike this down as well, and they would say that this is not harmful either, drawing on from the sort of similar facts in that case where they are burning across, in a Black neighborhood.
Specifically, since it was a gesture and not, it could have been considered as a gesture and not really speech per se.
Maybe the American students want to comment a little bit more on the 2 videos. Please feel free. Oh, Ravleen has her hand raised. Yes, Ravleen, please go ahead.
So I definitely think that the Indian video would be considered hate speech in America. I think my biggest reason would be because they're pretty much trying to vilify Muslims, and to just straight out say Muslims and say that if they have these positions that it would be like a wrongful thing. I think 100% that would be considered hate speech, and that wouldn't be allowed here. And even if you see during Donald Trump's regime, when he was trying to enact certain acts against Muslims, it took him like a 3rd round and like take out the word Muslim for it to even be enacted. So I definitely think that is hate speech.
Would someone from group 2 want to respond to that, especially since I think we'd reached a conclusion that it might not amount, group 1 might not amount to hate speech in the earlier discussion. Monika, please feel free to add your points. I noticed your hand was raised.
So that was with regards to Ravleen's opinion. That I'd like to disagree from that. Just because even if you take present day examples where Fox News, which is a popular news channel in the United States, they do air a lot of content that may be considered Islamophobic, and that is often considered Islamophobic. And even then, though there are suits filed against them or on First Amendment, very little action has been taken by the court just because how liberal the First Amendment protections are in the United States. So I think that the group's opinion in the matter that the video in India would be protected as free speech and not hate speech still stands.
I think it's difficult. I mean, I think Ravleen is right that it would definitely, like the Muslims in the country would definitely try to attack it as hate speech, and I think it would probably go to the courts. But I also think Naveen is right that probably the commentator would defend it on free speech grounds and would have some constitutional precedent to say, this is free speech and it's not imminent to inciting something. But this again comes back to what I was saying before, is that it's all going to depend on who the judge is. And I don't know if this is as true in India as much as it is here, but the position of the judge on particularly hate speech really, really matters. Because I think my colleague, I think your name is Jinno, is that right? Was saying about the march in Charlottesville, that the free speech aspect of it is difficult to place in terms of where who specifically it is that they're insulting, and that's like a big gap where you can get away with quite a lot. I think if like that march that we showed in the video, that's actually the one in Charlottesville, which was on the campus of the University of Virginia. It's not the Skokie one from the case. So they weren't actually going through specifically a Jewish neighborhood or specifically a neighborhood of people of color. They were going through a university campus, and not just a university campus, but a university campus built by Thomas Jefferson, who's a very well-known white slave owner from, our colonial period. And so I think it has a different aspect depending on who the judge is and also where the thing is taking place. And so I think Ravleen is right that somebody would probably attack that video on hate speech grounds, and the other side would say that it's free speech, and then ultimately whether it is or not would be decided in the court, and the court will depend on who the judge is very much.
Yeah, I think it's got a lot to do with the US president's involvement in the appointment of judges. So like, I read the news about, like, say, when the presidency changes, the judges sitting on the bench also change. So there's a lot of references to their opinion on, say, abortion or any different like social issues. But I think in India, like, the system has its own issues, but I don't think the involvement of, like, say, the political involvement of the judges really plays a role here.
Thank you, Naveen. Do any of the other students want to respond to the aspect of, in fact, very interestingly raised by both sides, and Naveen on subjectivities of the judge deciding the matter, which also ties in with Ravleen's larger point on how often restrictions on freedom of speech are disproportionately imposed on certain minority communities.
Also, I had another point. Could I raise it if no one else has any other points?
Naveen, let's see if anybody else is going to say anything. Otherwise, okay, you can go ahead.
Yeah, so like, I was just reading about the recent issues with regard to like people refusing to use transgender pronouns when they address other people. And I think the larger conservative opinion was that they had the right to say whatever they want, even if it offended the other person. So again, like, they would raise the extremely liberally worded free speech provision, the First Amendment, to not even respect another person's opinion, another person's pronoun, like how they want to be addressed. So, and I think there's been a lot of controversy with Dave Chappelle and I think Jordan Peterson, who's spoken like at length about these issues, and it is constitutionally protected. So I think, adding on to the previous conversation, like, I think that video would definitely come under the protection of the First Amendment and would not be considered as hate speech, because words of such comments and statements have been upheld and not been prosecuted for saying those things. Like, people still continue to share whatever they want under the bandwidth of the First Amendment. Yeah, so yeah, that's about it.
Yeah, if just add to that and what was raised by Ravleen and Syed. So I think even when the first group was discussing, we did talk about how this kind of speech is inherently harmful. This is, using religious tactics because this was also against the bureaucracy. So there is also a political color to it. There is also allusions to it being related to terrorist activities, which is clearly Islamophobic speech. But I think the reason we arrived at that conclusion is because we did not have anything to fall on, either by way of precedents or by way of legislation. So I don't think there is a hate speech legislation in the US. And like Naveen said, the First Amendment is also broadly worded, and it's a positive sort of right, as opposed to the Indian Article 19, which is a negative right. So I think the reason we arrived at that conclusion is not because we thought the speech in itself, from a moral
sort of standpoint, we do think it's wrong and it's harmful, things like that. But I feel like from the US, at least me, I'm maybe not speaking for the entire group, but I feel like we do not have anything to fall back on within the American law context to sort of hold that as being hate speech legally. So I think that's where we characterized it in this manner.
I think Mohammed had his hand raised.
Yes, so I think it's important to understand that it may probably, from a subjective perspective, it could, I mean, it certainly does amount to hate speech. But the question to be asked is not whether, it amounts to hate speech or not. It's whether hate speech is, protected by the First Amendment. Can hate speech be made under First Amendment? And if so, the extent to which it can be tolerated. So the mere fact that there is hate speech does not really, negate the protection extended by the First Amendment. So even if it is a hate speech, you cannot impose restrictions on it because of the jurisprudence on the First Amendment.
Thank you, Mohammed. Would any of the American students like to comment, especially even the controversy surrounding Dave Chappelle's comments on TERF or trans-exclusionary radical feminism? Would anybody want to comment on that? Amandeep, I think you were a part of group one. Do you have any comments that you want to make? Anything you want to add to what the students have already said?
I think most of what I had shared and said, Joni already stated our viewpoint. One thing I think, I feel like it was Mohammed that mentioned something that's kind of interesting is like how intertwined politics and then also religious beliefs, at least in India, are. And I think that makes it, that puts the whole position in a more interesting, like whatever the news reporter guy said, puts it in a more interesting context, because then it's like, is this religiously motivated or is this politically motivated, and like what the overlap between the two of those things are.
I just want to read something from one of the reading materials which was written by Stone. The point is not that such expression is harmless. It is rather that there are better ways to address the harm than by giving government the power to decide which ideas and opinions the citizens of a free and self-governing nation may and may not express. So I think that is the point here, because even if it is hate speech, it may not, it is probably dealt in alternative methods by not restricting the speech itself, by probably initiating criminal prosecution on attempt or incitement grounds.
Yeah, and I also want to like bring up the case law which Vismay was mentioning previously. So in that case, what is like definitely like interesting to note is that the rally, the Nazi rally, which wanted to go through that Jewish neighborhood, got state protection. So around 24 of those like Nazi people, like in that parade, were protected by 400 policemen. So I think it's interesting to see that the positively worded First Amendment rights in the US gives a obligation to the state to protect speech of any kind, even if it whatever it infringes upon the rights or beliefs of other people as well. So I found that to be really interesting, that the state in itself gave protection to promote hate speech and for them to express it just because they have the freedom to say what they want.
Thank you, Naveen, for that. And I think we're running out of time, so we'll probably close this discussion for now. If you have any further comments, please put them on the chat box and we'll try to respond to it. And we'll move on to the next items on our agenda. This was a very interesting discussion where very pertinent points were raised on both how legally you would look at an issue and how socially you would look at an issue. And like all the students raised, maybe when we do look at a particular form of speech or expression, we may think that it is hateful and there could be challenges mounted to it on these grounds. But how the courts look at it would vary both in terms of the legal provisions and subjectivities of the judges involved in the matter. So now we will move to the next item on our agenda, where we will have remarks by faculty members from both universities. Kalyani, I'll hand that over to you.
Thank you. I'd like to first call upon Professor Nandita Narayan. Professor Nandita works as an assistant professor in law at NUALS Kochi. She completed an LLM in constitutional law and criminal law at the School of Legal Studies, COSAT, and she's currently offering a course on comparative constitutional law for the fourth-year students. As a research scholar, she's also doing her PhD in artistic freedom and reasonable restrictions, and her areas of interest include public law, comparative studies, and jurisprudence. Professor, on to you.
Thank you so much, Kalyani. It's so good to be here today. So I don't want to take up much of anyone's time because it's almost 11 in India here. So I'll just quickly go through what I have in mind. So I'll start with giving two examples, which I found very interesting. And interestingly, it is not cases that have come out of Indian courts or the US courts. And if you notice, the actual circumstance of both these cases are very similar. So first instance is where a public school teacher, high school teacher, while delivering his lectures in class, he made an anti-Semitic statement saying that Jews, the whole World War is a farce, and the Holocaust, where the Jews were persecuted, is a farce, and it was something that was created by the Jews itself to gain sympathy. So that is the first example. The second example that I'd like to take is there was a historian and a very world acclaimed author, historian, and he was called for interview by a radio station, and this was a live broadcast. And while he was asked certain questions, he also made certain anti-Semitic statements saying that he has findings that he has come across during his research in history of World War I, where the Jews were not, the majority of the Jews were not gassed in the gas chamber. In fact, they died of natural causes such as typhoid, etc. Now, in both these instances, there was a penal statute in the country, and they were prosecuted and convicted by the lower courts with the help of this penal provision. And the challenge was on the constitutional validity of the particular provisions in the light of free speech provisions in the respective constitutions. Now, I'd like to take the names of the countries and the names of the case laws. The first one is R versus Keegstra, and the second one is United versus Broadcasting Company. The first case was a 1919 decision in the Canadian Supreme Court, and the second case is a South African Constitutional Court decision. Now, interestingly, the first situation, the court upheld the constitutional validity of the penal provision, indicating that the person did not have the freedom to talk in the manner that he did within the classrooms, even in private spaces, because of the fact that he was a public school teacher. And in the second instance, the Constitutional Court of South Africa struck down the constitutional validity of the particular penal statute and upheld his freedom to speak and talk of his research findings on live broadcast. So I hope you understood the stark differences in the decisions of cases with similar fact situations. So what this points at ultimately is, when we talk of free speech in a particular country, what we are trying to deduce is very associated with that country. And in the process of deducing this free speech theory, you're actually looking at the value that a particular country attaches to the concept of speech and attaches to the concept of free speech. Now, how will you deduce the value? Most of the times, most of the law students think that it is to do with judiciary, judicial reasoning, etc. Of course, a large chunk of the free speech theory will be determined by judicial reasoning, but there are also other factors. Like if I were to like point out and put it in pointers like 1, 2, 3, 4, 5, the first part that would point towards a free speech theory is of course the documents that led to the creation of the constitution. So if I were to talk about hate speech particularly with respect to India, so I think in your even in this session, there is a lot of reading material with respect to CAD, Constituent Assembly debates. Now, the importance of, I'm not going into the importance of Constituent Assembly debates, but particularly with hate speech, there was a lot of debate on the provision of sedition. Because of our colonial past and because of the fear that we will be subject to similar colonial laws by the new government, it was heavily debated, and it was in defense to the provisions under 19.2, to the provision of sedition, that Ambedkar brought out this speech that I think Kalyani was mentioning earlier, where he defended the reasonable, he defended the restrictions, saying that he basically brought out two misunderstandings. Misunderstanding number one is that the free speech jurisprudence in the US is not absolute. We have derived our free speech jurisprudence primarily from the US Constitution. And in USA, it is not absolute. I agree to the point number one. The second point, what you brought out was with respect to, it is not the judiciary. So there was a lot of argument saying that, the judiciary had created certain exceptions to the free speech doctrine in the US, and it was the role of the judiciary to do so. He defended this, and he said that using police powers, the concept of doctrine of police powers and implicit powers that is vested with the Congress, it was the Congress that has the power to make these laws. And the judiciary is just interpreting the laws that is made by the Congress. So this is where I have a slight disagreement, because this was at a time, the Constituent Assembly debates went on for 1.5 years, and especially with respect to free speech, Article 13 in the draft constitution was during 1949, later part of 1949, that is December, November. That was when the crux of the whole provision was defended and argued and all that. And this was soon, Chaplinsky, the case of Chaplinsky came in 1942. After Chaplinsky, we have Dennis versus US, to Cohen, to the Ku Klux Klan that we were all talking about right now. Then you have Brandenburg versus Ohio, to the recent decision of RAB. So you have a plethora of cases where you see the judiciary taking a stand and saying that, this amounts to free speech and this doesn't amount to free speech. So the fact that the judiciary doesn't have a role, much of a role, doesn't hold good today. It's almost become redundant. And the second provision, the second contributor to the theory of free speech is the Constitution itself. When you talk about the Indian Constitution, I would like to bring in the First Amendment because that is where you can see a turning point with respect to the Indian free speech jurisprudence. So initially, before the Constitution was made, if you were to talk about the, all the documents that led to the draft Constitution, starting from Government of India Act, etc., 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 you can see that majority of the speech provisions were unbridled. As in, the restrictions were minimal. It was with the draft provision that slowly the restrictions started emerging, and a large number of restrictions found its place in the draft constitution. This is really because of the political background, and it cannot be viewed in isolation. You have to view the draft constitution in the political background or political history of India. This was a time when the partition was taking place, and there was a lot of fear in the minds of the constituent makers with respect to speech and whether it will amount, all those violence, incitement and things like that, whether you need to put in specific provisions was at the back of the minds of all the debaters. And I would say this is one of the key contributors to the fact that the expansions the restrictions kept expanding. So in the draft constitution, you see a large number of restrictions. And then finally, in the First Amendment, you have, I'm not going through the cases, you have Ramesh Tapur and Brij Bhushan, which contributed to the First Amendment. You have concepts such as in the interests of added, you have concept of reasonableness added, public order and incitement. So what was seen in the draft constitution vis-a-vis what is seen now today is the restrictions are much broader than what we saw in the draft constitution. Because when you say in the interest of, it means that it is not only under the specific heads given under 19.2, it could be in the interest of these heads also, which implies indirectly that the state can make statutes in the interest of so and so and so restrictions. Similarly, it's not only through statutes, it can be even executive actions. So if a law gives the executive the power to make or do actions restricting free speech, it can be done. For instance, under Dramatic Performance Act, the police commissioner is given the power to restrict drama if the police commissioner of that local area or local municipality feels that it will amount to a breach of peace. Now, the question is whether breach of peace can be protected under 19.2. Yes, it can be protected under 19.2 because you have public order under 19.2 post the First Amendment. And public order has been defined to include public tranquility and breach of peace. So you understood how the whole thing has been diluted within the Constitution itself, so that the restrictions are much, much broader than what it was initially. Now, the third aspect, so we went to CAD, we went to Constitution, and the third aspect are statutes made by the Parliament or the state legislature. So like I was mentioning earlier, there are a large number of statutes that primarily focus on hate speech provisions. For instance, you have the Representations of People Act, you have the SC/ST Prevention of Atrocities Act. And it's very interesting to see that the wordings under these statutes, for example, the SC/ST Act legislation, even talks about, causing or intentionally making another individual feel bad, hurt, or if it causes some sort of annoyance or disturbance by the use of the term, by the use of their caste, the term of their caste, then it can amount to a speech violation and it will be penalized. So you can see the broad spectrum and how particular statutes have defined free speech, and it is actually an overbreadth that we are seeing here, but it has not come up before the court. And even if it has come up before the court, the judiciary has taken a very low standard of adjudicating free speech, especially hate speech. Just one more thing that I wanted to bring out is, which you have already discussed, is with respect to the standards that are brought out by the judiciary. So if it is a very high standard like we see in the US, so the question is not what amounts to hate speech, but whether the particular hate speech is protected speech under the First Amendment. So majority hate speeches are protected in the US Constitution because of the standard adopted by the judiciary, and it's a very high standard. Whereas in India, though we have adopted tests like imminent danger test, etc., we still follow a very lower differential standard, which means that the speech spectrum is very small when compared to the unprotected speech action spectrum. One more point that I wanted to add is with respect to OTT platforms and social media. That is something that I didn't see anyone, bringing out in our discussions. How can you regulate? So, and the role of intermediaries in all these areas. So you can see how, if you take the Indian context, you can see how Facebook posts have resulted in arrests. You can see how, a large number of, posts on Twitter, etc., have been taken on by the intermediaries itself. So there are a huge number of questions with respect to the role of the intermediary, the role of the individual, the role of the state, etc., with respect to hate speech in social media. So thank you so much for having me. I think I'm done. Thank you, Kalyani.
Thank you. Thank you so much, Professor. Thank you for actually giving us a very insightful yet comprehensive understanding of the provisions and the historic context as well of each of them, and highlighting how social media comes into play towards the end. Thank you. I will now like to invite Professor Monika Batra Kashyap. Professor Kashyap is a distinguished practitioner in residence and affiliate faculty at the Seattle University School of Law. Before joining Seattle University School of Law, Professor Kashyap was an immigration attorney at the law firm of Gibbs, Houston, and Prof in Seattle. And here she represented detained and non-detained individuals in removal proceedings. Professor Kashyap has been a visiting clinician with Ronald A. Peterson Law Clinic at Seattle University of Law, where she teaches gender violence, immigration clinic, and immigration clinic. Her scholarship is focused on the intersection between immigration law and critical race theory. She has published multiple articles in not limited to, but including the California Law Review, Tulane Law Review, Fordham Urban Law Journal, and New York Review of Law and Social Change. Professor Kashyap has also served in the board of the Northwest Immigrants' Rights Project for nearly a decade. She has also served on boards of 2 organizations dedicated to ending violence in South Asian communities. She received her JD from University of California, Berkeley, and her BA in Middle Eastern and South Asian languages and cultures from Columbia University. Professor, the floor is now yours.
Thank you so much, Kalyani. And thank you to everyone. This has been such an amazing collaboration. And I am just so struck by this workshop and its willingness to sort of interrogate and question and to bring together the opportunity for all of us to interrogate and question the very structures and institutions that are the foundation of our countries that have a shared colonial history, and to really be willing to see how baked in those same colonial impacts still impact us. I know it's late there. In fact, I was myself doing a presentation at midnight my time yesterday, so I'm a little tired myself. So I have sympathy for the Indian students for whom midnight is approaching. So I want to keep my remarks as short as I can. But one thing I thought I would offer is exactly that: critical race theory as a theoretical framework for us to continue to think about how to think about hate speech and freedom of speech. Now, what is critical race theory? I'm sure many of you know, but I'll just give you a couple of definitions. It is a framework that reconstructs First Amendment jurisprudence in the United States so that it is grounded in the experiences of people of color and acknowledges the real and complex harms of racist speech. It is an intellectual movement that examines how traditional status quo and political interests serve to maintain structures of racial subordination. Most of all, I want to offer you a book that I put in the chat. The link in the chat is a book called Words That Wound: Critical Race Theory, Assaultive Speech, and the First Amendment. It is not a new book. It was put together by 4 pioneers of the critical race theory movement here in the United States: Mari Matsuda, Charles Lawrence, Richard Delgado, and Kimberly Crenshaw. The link that I put in the chat is a good link. It has each chapter, there's 6 chapters. You'll see chapter 6 is actually by Mari Matsuda, and she talks a lot, she does an analysis, a critical race theory analysis of the case that we read today, RAV. You may find that interesting. And also the chapter by Kimberly Crenshaw offers an intersectional theoretical framework that includes to hate speech that includes gender, which I think you will also find interesting. In the end, critical race theory, I feel, can really offer an opportunity to give us all an anti-subordination interpretation of the First Amendment. And I believe that that is what all of you together collectively were coming up with. And hopefully the theoretical framework of critical race theory can support you. And I encourage you to use it and to rely on it and to research more about it, especially in the Indian context and how it can apply there. So as we come upon the hour again, I just want to end by commending all of us, commending all of you students who came up, who showed up both early here in Seattle and late in India, to be part of something like this and to realize how anti-subordinative this space is, and to join with one another in continuing to question and interrogate the very structures that bind us together. Thank you.
Thank you, Professor. I would like to thank both Professor Nandita Narayan and Professor Batra Kashyap for giving their remarks. It was interesting to note that Professor Nandita brought in sort of new issues for us to think about on how we look at hate speech itself and some of the contemporary issues that arise on account of the new forms of sharing information on digital platforms. It was also interesting that you highlighted the constitutional history of the freedom of speech provision in India. And Professor Batra Kashyap tied up the discussions we had today within the larger theoretical framework of critical race theory itself. Thank you so much, all of you. If the students have any questions, please feel free to ask.
If I may just add one last thing, what wasn't mentioned, I should have mentioned at the outset, is that Seattle University School of Law is the only law school in the country that has a dedicated center to the study of India and bringing together scholars and academic issues that relate to both India and the United States. So that's called the India Center for Law and Justice. So for any of you who are considering doing an LLM in the United States, you may find a very supportive home at Seattle University. And if you're interested, please Google the Seattle University India Center for Law and Justice and find me, reach out to me. I will give my contact information to Kalyani and to Meenakshi. And so you can always reach me that way as well. Thank you.
Thank you, Professor.
Meenakshi, you're on mute.
I think you're muted.
Sorry. Yeah, thank you. I was just saying, if there aren't any questions, maybe we could end this session. Before you all go, I would request all of you to turn your cameras on for a picture. Yeah. We'll just give a minute for people to switch their cameras on. Thank you.
Thank you.
Thank you so much. Thank you all for joining us. Thank you to both sets of students for the engaging discussion. And thank you, Usha, for supporting us on this as well. I think that's it from our end. Good night to the Indian students and all the American counterparts. Please have a great day. Yeah. Thanks.
Thank you. Thanks, everyone.
Thank you.
Thank you.
Thanks.
I hope you can see my screen.
Yeah, we can.
So this is the last session of the second workshop, which is a part of a series of 4 workshops. It's going to be a summary session as well as us introducing the essay question to all of you. So of course, Meenakshi and I will take you through all. Oh, I see a hand raised. I don't know if that's on purpose. Okay, I'm going to continue. And we're going to take you through all the readings and the cases that we did, that we covered in the past 3 workshops. We can have a question and answer session for around 5 minutes. And we will then introduce the essay competition as well as the essay question to you. The students get an hour to write the essay competition, after which we will have Professor Mini's closing remarks, a feedback session, and then we will close this workshop. I hope that sounds okay. Okay, so in session 1 of our workshop, we talked about America's and India's constitution. Meenakshi, do you want to start?
Yeah, sure. So we started with discussing how the 2 constitutions came into being. We went through the entire constitutional story of how the different events and documents that sort of inform the American Constitution making process. And similarly, in the Indian context, we had seen a video that takes us through these events and the history of the Indian Constitution. After this, we had a discussion on 2 questions. The first was a normative question on whether constitutions should be made democratically. And what we saw was most students saying that it should be made democratically. But we did see a sort of disagreement, or a discussion rather, on what is the level of expertise the constitution making body should have versus the sort of representative aspect of a constitution making body. After this, we had discussions on the empirical question of whether the Indian and American constitutions were made democratically. Here, students highlighted 4 main aspects. First is the election of members to the constitution making body itself. In India, it was indirectly elected. In the US, they did send delegates from 12 colonies. Then they spoke about representation and how possibly the Indian constitution making body was more representative than the American counterpart, but they didn't take into account the time and context in which these 2 constitutions were made. And then we highlighted some of the processes that were adopted in the 2 constitution making bodies. And they both were in both cases, it was highlighted that in the Indian context that there was deliberation, and in the American context, we did see processes such as ratification, which sort of ensure that there is more say of the states in the entire constitution making process. So these were the discussions we had. After this, Kalyani took over.
I think we highlighted the doctrine of separation of powers in our discussions, and we went through Federalist Paper 51 as well as the Constituent Assembly debates, and focused on Ambedkar's thought on the separation of powers. What we did realize that both of them did in fact agree on the necessity for the doctrine of separation of power. However, it did differ slightly in the way or in the manner that they wanted it to be adhered to in their countries. We know that Ambedkar took a midway, did not want to create an imperium, which is a supreme power in the hands of the judiciary, but did not want to take away their independence either. Similarly, for James Madison, although he didn't worry about the creation of an imperium, he did suggest that the legislature could be the most powerful, and he also provided for methods by which each of the organs themselves could be independent and have no relation or no reliance on the other departments.
I think this was followed by the activity where students were given a hypothetical, and then they were asked to discuss. They were split into 2 groups, and one group representing James Madison's take on this hypothetical, and the other group representing B.R. Ambedkar's take on this hypothetical. And we had very valuable discussions on that front as well. And then after this, we had Professor Arun Thiruvengadam's speech, and in which he had highlighted the value of looking at originalist position. And he actually took us through how courts have done this with the help of the Balaji Raghavan case. And he also sort of used this to highlight how the colonial past has informed our constitutional history and practice.
Thanks, Meenakshi. Do you want to start with session 2 as well?
Yeah, sure. So going to, this was for, so now that we had a sort of understanding of how the two constitutions came into being, we moved to the substantive session on freedom of speech in US and India. And over here, we started with, we just took you through the texts itself of the freedom of speech provisions in India and US. And then we sort of looked at how in the US context also there are some restrictions on freedom of speech and what we consider to be unprotected speech and protected speech in the US context. And then we went through the Constituent Assembly debates on freedom of speech in India and whether the restrictions should be enshrined in the Constitution itself. Followed by this, I think Kalyani took us through two cases.
Yeah, we did Grove Press versus Gerstein and Perumal Murugan, both cases on publication and obscenity.
I'm just going to mute them. Yeah, sorry.
Yeah, that's fine. Thank you. Good?
Yeah.
Okay, thanks. So in Grove Press, we saw how there was a ban on Henry Miller's Tropic of Cancer, and how the court argued that unless, until the content was utterly without any redeeming social value, you can't really consider it as obscene. And if it is adding some sort of value, whether socially, scientifically, or in any other way, then you shouldn't ideally consider a book obscene. Similarly, in the Perumal Murugan case, we also saw the book by Perumal Murugan, where the court actually upheld the author's freedom of speech and expression, and also stated that it was the obligation of the state to ensure that there was no law and order issue, especially when there's a book which might upset sentiments of certain factions. However, it needn't necessarily be seen as obscene by the community at large. Just a housekeeping rule. I request everybody who is not speaking to please mute themselves. Thank you. After this, we had an activity which looked at a paragraph from Lihaf, which is a book, short story by Isma Chugtai, and the students engaged in a discussion about whether the paragraph was in itself obscene. And I think under both the Indian as well as the American provisions, and I believe we reached a consensus where we realized that with the community standards test and with respect to freedom of speech and expression, it wouldn't be considered as an obscene paragraph in the book itself. After this, we had Professor Sitaram Kakarela, who is a CLPR trustee, talk about the role of comparative constitutional studies and how it is important for the study of history and how it is important to study the history of modern law. He also highlighted how we need to move from functionalism to sort of see the context that laws were made in, which is exactly why we're doing this workshop. And I feel like it was a great concluding remark for this particular session.
So we'll move on. So we had the third session.
Second.
Sure.
You can speak, don't worry.
Yeah, we had the third session, which was the interactive session with students from Seattle University. And in this, the theme of this session was hate speech. So once again, what we did is we started with the texts of the freedom of speech provisions in both countries. And from there, we went on to discuss two short pieces. One, the excerpts from the Law Commission report, and another, a piece by Jeffrey Stone on hate speech and the American Constitution, just to give context in the way hate speech is viewed in these two countries. Then I think Kalyani took us through some cases.
Right. We looked at Amish Devgan versus UOI and Rapp versus City of St. Paul. In Amish Devgan, the Indian case, we saw that a journalist was charged with multiple accounts of hate speech or anti-religious comments in his television show. And it was held that it was held that those charges were actually prima facie correct because he did violate the freedom of speech and expression. Whereas in Rav versus City of St. Paul, we saw that the case was a little different from the Indian context because there was a case of petitioners burning a cross on their neighbor's a field, but the court held that it wouldn't be unconstitutional because one, gestures aren't under the ambit of the First Amendment, and second, fighting words as such wouldn't either fall under the ambit of the First Amendment. After this, we had an activity where we saw 2 videos and we tried to see if they would be considered as hate speech under the Indian provision as well as the American provision. I think this activity gave us a good chance to look at how the 2 countries differ in their hate speech laws. Although neither really has a definition of hate speech, we see that one allows for more freedom of speech and expression without curbing it, even though it might be necessary to in certain instances, while the other has more regulations that curb it in a sense.
Followed by this activity, we had actually 2 remarks, speaker remarks. First, we started with Professor Nandita Narayan, who took us through various issues in the way one can look at hate speech. And she does this by actually starting on 2 different constitutional courts looking at the concept of hate speech itself. She looked at the Canadian court and the South African court. Then she actually took us through this constitutional history in India to sort of understand how freedom of speech has been looked at in the Indian context. She also highlighted some of the sort of newer issues that emerge with new technology and social media, and how there are different questions of who can be liable when it comes to hate speech on digital platforms. This was followed by Professor Batra Kashyap's remarks, who sort of tied in all of these discussions within the larger theoretical framework of critical race theory, and forcing us to sort of think of how the concepts of freedom of speech and hate speech itself can be looked at in sort of the larger structural issues of race in the US context. So I think with that, we sort of concluded the 3 sessions, and we've had a fair amount of discussions on a lot of issues, touched upon very interesting nuances on how not just the legal framework is sort of set up in books, but how it sort of operates and translates in practice as well. So with that background in mind, we thought we'll introduce this essay question, and which is essentially, is studying US constitutional history and practice useful in understanding contemporary constitutional developments in India? So the basic rules for this is you can answer this question exclusively relying on the material provided in the workshop, the readings, the cases, legal provisions, and the discussions we have had during the sessions. You have 1 hour to write this essay. We're expecting about 500 to 700 words. Please do not plagiarize. We will be conducting a plagiarism check, so please just do not plagiarize. Try to write as originally as possible. And some of the points you can keep in mind while writing this essay, just sort of to think about, is what influence did the US Constitution have on the Indian Constitution making process, if at all it did have? What were the institutions and processes in the American constitutional founding that India adopted, added to, left out? What could we say that we learned from the cases on freedom of speech, particularly hate speech in US and India? So these are some of the points you can think about, reflect on while you answer this question.
Feel free to screenshot this slide. What we will do is we will pause for an hour. So we will resume back at
10:25.
Yeah, 10:25. You can log off, stay on the Zoom call. If you have any questions, please let us know. We will stop the session at 9:25 exactly, so everybody has an hour to answer the question.
Yeah, we will put in the email ID you're supposed to submit your essay to in the chat box.
I'll do that right away.
Yeah, so you can submit your essays by 10:25 to that email ID.
So are we supposed to cover all the 3 points that are mentioned?
No.
Or is it fine?
You can just focus on one also. The point is just, these are just things for you to think about. So whatever you feel comfortable with writing on, please go ahead.
All right, thank you.
There's an issue. It's US-India workshop at clpr.org.in, and it's also in the chat box.
All the best.
Good luck. If you have any questions later, just feel free to put it in the chat box and we'll answer it right away. I think we can pause now. I hope you've all taken screenshots because I'll then stop the share and we can resume at 10:25. Thank you.
Yeah. So the next item on our agenda is closing remarks by Professor Mini. Professor Mini is a professor at the National University of Advanced Legal Studies at Kochi. She is interested in working on themes of social justice, and she heads the Center for Competition Law and Policy at NUALS. Thank you, Professor, for joining us today. The floor is yours.
Yeah, I think some issues with the video. If you are able to see me,
we can see you, Professor. Yeah.
Okay. But my screen is full blank. Okay. Anyway, warm good morning to all of you. So now I'm not going to give a lecture on this thing. I'm just giving some concluding remarks. Just my understanding of this particular concept. India believes in unity in diversity. Maybe as the impact of globalization, the nature of societal structure, the societal values are undergoing rapid changes. It is the need of the hour to ensure that the society follows constitutional culture. That is the main challenge India is facing now. In India, we debate on constitutional morality, constitutional supremacy, right to privacy, freedom of speech, etc., and also the judicial interventions through constitutional interpretation. A comparative approach is used for judicial interpretation. One of the main elements of this approach is the court depicts the similarities in the provisions of constitutions and statutes of other universities. In the area of judicialization, a comparative analysis is important for progressive interpretation of the constitutional provisions also. So, a comparative engagement is helping us to identify the similarities and the differences and to explain why these differences are. We discussed in this workshop, we got opportunity to discuss foundations and some of the fundamental principles of Indian and the US Constitution. We discussed the doctrine of separation of powers, thoughts of the framers of the Constitution, freedom of speech, and the extent of restrictions along with the case laws. So this was a very different experience and exciting learning experience for all of us. We really appreciate the way in which the workshop is conducted, and especially the efforts put by Ms. Meenakshi and Ms. Kalyani by providing reading materials, case discussions, student activities, interactive sessions with the Seattle University School of Law faculty and students. And all these are actually suitable for achieving the objective of the workshop. So on behalf of NUALS, I place on record our sincere gratitude to the US Consulate Chennai and CLPR for giving us this exciting experience. And I especially thank Usha ma'am, and special thanks to Professor Sudhir Krishnasamy also. And I think Nandita, our course teacher, no, she may say a few words. Nandita, over to you. Yeah.
Thank you, ma'am. So I just had a few, words with respect to the entire program. It was really nice. Actually, like, during our LLB studies, during our, coursework with respect to LLB students, it's very unlikely that we go into such depth with respect to comparative studies. And as I think this goes out to all the LLB students from NUALS and from the US Consulate who are here. I think you all know the importance of comparative studies. I'm not going into that, but personally, for me, constitutional law I used to look at constitutional law with a, with a thought that, what is there in this? There's nothing more to it. You have provisions within the constitution and you have judicial decisions. What is there in it? There's nothing more to look into, So once I started delving into it further, it became very interesting. And the interest grew, and it is primarily because of certain doctrines that were put out by the judiciary in several cases. And then I started, going into the historical evolution of the Constitution. And then that's when I came into comparative studies. So this whole spectrum of comparative studies, not only with respect to India and US, I'm talking with respect to constitutions like South Africa or Canada, and then you have the ECTHR, the decisions by the ECTHR. These are all extremely interesting for those who want to pursue academics and those who are interested in constitutional law. So I think this workshop would have really helped all the students to probably streamline the interest and think of what they want to do in the future. So thank you, CLPR and the US Consulate. Thank you so much for having me as well. Thank you, ma'am. Thank you.
Thank you, Professor. Usha, is there something you would like to say before I move to the feedback part of it?
So on behalf of the Consulate, yes, kudos to CLPR for putting together such an awesome content, how well we could take the theory and apply in those case studies and analyze them was very interesting. And of course, NUALS, we always had this partnership with Dr. Mini and VC Professor Sunny. We're so thankful to them for extending this to their students, and we really look forward to more such cooperation, and it was a great engagement. We look forward, probably we could meet in Bangalore at the end of the whole program, hoping everything, the environment is clean and fine, and we could meet in person for the award ceremony. So looking forward to your essays to see what your takeaways were. Thank you again all, especially Meenakshi and Kalyani for your excellent presentation. And of course, students, but for you on a Sunday morning, really, without you, we won't be able to do this program. You were the key nucleus of this program. Thank you again.
Thank you, Usha. And just before we close, we thought we would share a feedback form with you, which I'm just going to put on the chat box. And as I conclude, maybe all of you can fill it in. It's of course not a test or a quiz. We only want to gauge how the workshop has helped you, what it has helped you understand, and how we can improve in the future workshops, which is why this feedback form is actually extremely essential for us. And if you have any comments, any improvements, please feel free to put that in the last two questions that mention it. That being said, at CLPR, we believe that a vibrant constitutional culture is the key to sustain India's democracy. And so to popularize Indian constitution and build a community of constitutionally aware citizens, we've designed and produced a t-shirt which contains India's beautifully illustrated preamble.
If any of you are interested in buying the t-shirt, you can visit clpr.org.in/shop, and the t-shirt is available there. Other than that, I think we just wanted to extend our gratitude to NUALS and the US Consulate for ensuring this workshop happens, and all the students for participating in all sessions very actively and submitting their essays. So I think that's it from us. All of you have a great day. Have a great rest of the weekend. And thank you for tuning in.
Thank you. Have a great day.
Thank you.
Thank you.
Thank you, Meenakshi. Thank you, ma'am.
And thanks to all my students. Only because of you, we are able to conduct this in this manner. Thank you so much.
Thank you.